Hi, welcome to this presentation. This section will navigate the legal landscape in the real estate industry and see some of the applications of the rules and regulations to the standard sale process. The real estate industry is governed by various pieces of legislation. As an agent, it is essential to comply with the laws and their associated codes of conduct to protect consumers and maintain public confidence in the performance of real estate work. The two most important acts are Real Estate Agents Act 2008 and the Real Estate Agents Act Profession Conduct and Client Care Rules 2012. Real Estate Agents Act 2008 aims to promote and protect consumer interest and public confidence in the real estate transactions through a licensing regime and independent disciplinary process. The rules set out the professional conduct and the client care requirements for agents, branch managers, and the salespersons. It applies to all areas of real estate agency work. It is used as a reference for disciplinary action. Specifically, requirements include agency agreements, sale and purchase agreements, conflict of interest, trust accounts, and a business information display. The Real Estate Authority oversees the real estate industry, and the disciplinary tribunal educates compliance against the industry professionals. The 6 key milestones for a real estate agent during the standard sale process of a fee simple property are indeed crucial steps in ensuring a successful transaction. Each of these milestones represents a significant phase in the property sale process, requiring the agent to perform with due diligence, accuracy, and adherence to legal and ethical standards. So, first of all, the agency agreement is a legal binding contract between the seller and the real estate agency. When entering into an agency with a seller, agents must meet the requirement outlined in the Real Estate Agents Act and the rules. The agency agreement gives the real estate agency the right to market the property for sale. It sets out all the terms and the conditions of the contract, such as what you are as the real estate professional will do and what the seller will pay you. If a real estate agency is used to sell property, the agency agreement must be signed first. This is called listing the property. We recommend the agents selling residential property use the recommended standard clauses in their agency agreements. And the vendor should only enter into agreements with agents using them. Listing a property for sale requires compliance with legal requirements for verifying ownership and any applicable restrictions, disclosure of defects, or information to potential buyers. Therefore, agents should obtain and review the title to ensure that the information matches the details in the listing, identify issues or restrictions, checking zoning, or council requirements, and recommend legal advice for interpretation or clarification of title. If issues or restrictions are identified, potential buyers must be informed and advised to seek professional advice. Agents are responsible for reading all materials provided by the vendor, reporting any unverifiable claims or incorrect information, and withdrawing incorrect material in the case of conflicting information. Real estate agents must share all relevant information about a property with potential buyer. Rule 10.7 and 6.4 from specified disclosure requirements. Rule 10.7 also focuses on defects in the property, while Rule 4.6 6.4 covers information influencing the transaction. Agents should consult with vendor, provide written documentation, and advise buyers to seek expert advice. Section 134 to 137 of the Real Estate Agents Act and the Rule 9.14 and 9.14 addresses conflict of interest. So consent is required when a licensee or related person intends to purchase a property or business. Written disclosure is mandatory if a licensee or related person owns or has a financial interest in the property. Rule 9.14 and the Rule 9.15 prohibits actions that compromise this obligation in real estate transactions. So, Rule 9.2 emphasizes that you should not put undue or unfair pressure on either the vendor or the potential buyers when attempting to secure a sale. Communication is the key when dealing with multiple offer situation. It is crucial to keep vendor well informed of all offers in a buyer's interest, as stated in Rule 9.3. In a multiple offer scenario, prospective buyers should be informed that they are in such situation. This is typically done by having them sign an acknowledgement of multi-offer form. They should be advised to submit their best offer upfront, as there may not be an opportunity to make changes later. If a buyer withdraws from a multi-offer, leaving only one interested buyer, it is important to inform the remaining buyer. This allows them the chance to review and potentially revise their offer before it is presented to the vendor. So, when we enter into agreement, it is essential that we write up the sale and purchase agreement. Section 132 of the Real Estate Agents Act requires you to make sure that when a party has signed the sale and purchase agreement, an accurate copy of the agreement is given to them as soon as possible. You should have a clear instruction from the vendor about what is being included in the list of shadow, for example. If the vendor is planning to remove something that a buyer might consider a fixture, for example, the waste disposal unit or dishwasher, make sure this is clearly recorded in the sale and the purchase agreement. So, if any party makes changes to the agreement, for example, a change to the settlement date, this must be recorded on the sale and the purchase agreement and initialed by all parties. Initialing any changes on the sale and the purchase agreement is considered best practice. It indicates that each party has noted the change and accepted. It is important to make sure that the agreement is signed by all parties who need to sign it. If a party is a trust or company, make sure that all trustees or directors of the company have signed the agreement if they have the authority to sign on behalf of the other. Holding and releasing deposits. Under Section 123 of the Act, any deposits received by licensees in the transaction must be held for a 10-day period from the date of the receipt. This applies to all transactions. The licensee is authorized to release the deposit before the 10 days period only if a court order requires the deposit to be paid before the expiration of the 10-day holding period. All parties to the transactions sign the authority to pay the deposit before the holding period expires. Apart from satisfying the condition of having the unconditional agreement, requisition period expiration date without any claim is also a prerequisite to release the deposit. For transactions where deposit released before the expiration of the 10-day period is being applied for. Parties involved are advised to seek legal advice. Early deposit release could have significant implications if problems arise later in the transaction. The standard term in the ADLS Sale and Purchase Agreement, Clause 3.2, has outlined that the purchaser to conduct a final inspection of the property before settlement, typically 1 to 3 days before. The purpose of this final inspection is to ensure that the property and the shadows are in the same condition as when the agreement was signed, and that any conditions listed in the agreement have been met. It is not an opportunity to uncover pre-existing problems. Conducting a final inspection at least 48 hours before settlement allows both parties to reach an agreement regarding any issues. This is important, as failure to complete your side of the deal on the due date without valid reason may result in you having to compensate the seller. The term of such compensation will be outlined in the sale and the purchase agreement. So ensure that all the parties read and understand this provision. The property will not officially change ownership, and the final payment is not required until all the outstanding issues are resolved. So hopefully this section is helpful for your first engagement for your property deal. Thank you.